Thank you, Scott. Hello, everyone. What a newsy place this is. You're like the center of the universe right here, except the living room in Moscow where Edward Snowden is. But it's great to be here and talk to you and about the very hot issues that are before the courts and the law relating to privacy and related matters. But I thought I would come at it through the route of the Supreme Court. And I'm sure one question on your mind is, who's my favorite Supreme Court justice? Now, this is a somewhat difficult question because I've had a favorite Supreme Court justice for many years, but unfortunately he's gone. That's David Souter. I love David Souter because he was just so weird. I mean, in a group of basically computer professionals, you'll be pleased to know that one of the Supreme Court justices didn't have a computer, didn't have a cell phone, didn't have an answering machine on his dial phone in his house. He lived this sort of 19th century existence. He doesn't like electric light. He moves his chair around his chambers over the course of the day to catch the sunlight. He eats the same thing for lunch every day. He has a cup of yogurt and an apple, including the core, which is disgusting when you think about it. But anyway, Justice Souter, I thought, always had a wonderful perspective on what it meant to be a Supreme Court justice, because the Supreme Court is at once a very public and important institution, but it's also an institution where people don't know much about it. People don't know much about the justices, don't know who they are, don't know what... can I just tell the folks who are running the conference, my little clock isn't running, and I don't, after 2 or 3 hours, you might get tired of me. So there it is. There it's now. It's starting to see. I knew that would get him. Back to Justice Souter. Justice Souter. He had this great perspective because, they're famous but largely unknown, and he sometimes would have a little fun with that. And I'll give you an example. Now, for reasons that remain obscure, David Souter and Stephen Breyer are frequently mistaken for each other. Now, if you know what they look like, they really don't look anything alike, but it happens to both of them all the time. And not long ago, Justice Souter, as he often did, was driving from here in Washington to his home in New Hampshire, and he stopped at a little restaurant in Massachusetts to get something to eat. And he's sitting there, and a couple came up to him, and the guy said, "I know you. You're on the Supreme Court, right?" I said, "Yeah." I said, "You're Stephen Breyer, right?" And Souter didn't want to embarrass the fellow in front of his wife, so he says, "Yes, I'm Stephen Breyer." And they're chatting for a little while, but then he says, "So, Justice Breyer, I one thing I always wanted to know. It's a question Souter wasn't ready for." He said, so Justice Breyer, what's the best thing about being on the Supreme Court?" He thought for a minute and he said, "I'd have to say it's the privilege of serving with David Souter." Now, how can you not love a guy like that, right? But he's gone now, and I got to admit. All right, so let's talk about the Supreme Court by the numbers for a minute. All right, you have 6 men and 3 women. First time in history there are 3 women on the Supreme Court. There are 6 Catholics and 3 Jews. There are no Protestants on the Supreme Court. First time in history for that. There are representatives of 4 New York City boroughs on the Supreme Court. You have Sonia Sotomayor from the Bronx, Antonin Scalia from Queens, Ruth Ginsburg from Brooklyn, and Elena Kagan from Manhattan. Tragically, Staten Island is unrepresented on the Supreme Court, but perhaps future appointments will address that. Anyway, those are, I hope, some interesting facts about the Supreme Court, but I don't think they are really terribly important. Here's an important fact about the Supreme Court. There are 5 Republicans and 4 Democrats. I'm going to talk for somewhat longer, not 2 or 3 hours, but I'm going to talk for somewhat longer. But you now know most of what you need to know about the United States Supreme Court. There are 5 Republicans and 4 Democrats. And, we sometimes believe, we sometimes hope that the court is a refuge from the partisan politics that we're so familiar with on the other side of First Street in the Capitol or in the race for the White House. And perhaps at some glorious time in the past, that was true. But it's certainly not true now. The partisan disagreements that roil the country, that prevent people like the really distinguished nominee for Assistant Attorney General for Civil Rights, who was tragically, I think, rejected by the Senate yesterday. I mean, those sorts of fights, they take place in the Supreme Court just as they take place in Congress. And to see why this moment in the history of the Supreme Court is so important, this closely divided but Republican majority, the last time, it's important to look back at the last time the Supreme Court was not evenly divided. The last time there was a very clear ideological majority on the Supreme Court, and that was in the mid and late 1960s, when, towards the end of Earl Warren's tenure as Chief Justice, when there was a solid liberal majority. There were 7 liberals on the court, and there really was a liberal agenda that the courts, that the Supreme Court was pushing. And year after year, you saw dramatic movements of the law to the left, very, very intentionally. 1964, New York Times against Sullivan. Justice Brennan's famous opinion that changed libel law and gave the press important new protections. 1965, Griswold versus Connecticut, Justice William O. Douglas's famous opinion that created the constitutional right to privacy, said that married couples could no longer be forbidden from buying birth control. 1966, Earl Warren's decision in Miranda versus Arizona, the case that revolutionized criminal procedure and perhaps more importantly, changed television dramas forever. It's like the one right everybody knows they have, right? The right to remain silent. 1967, perhaps the best named case in the history of the Supreme Court. Loving versus Virginia. What was the case of Loving about? Loving versus Virginia, of course, it was the case about marriage. It was the case that said that states could no longer ban racial intermarriage. Think about that, 1967. There are people in this room who were alive in 1967, and I think I'm right about that. And yet it wasn't until 1967 that the Supreme Court got around to saying that racial intermarriage bans were unconstitutional. Of course, a decision that's much in the news today because of a similar fight going on about same-sex marriage. But it is worth remembering that in 1960, when Barack Obama's parents got married in Hawaii, their marriage was a crime in 19 states, and there were people in prison in this country for that crime at that time. So it is worth celebrating, frankly, that the country has come so far that laws like that are not only unconstitutional, but they are literally unthinkable. But, the changes, you never know how change is going to come at the Supreme Court because you never know when justices are going to leave. When Richard Nixon became president in 1969, 4 justices left in quick succession. Jimmy Carter is the only president in American history to serve a full term and just have no appointments to the court because there were no vacancies. But Richard Nixon was only president for 5.5 years. You'll recall he had to leave early. But he got 4 appointments to the Supreme Court. And who left? Earl Warren left, John Harlan left, Hugo Black left, and Abe Fortas all left. And who did Richard Nixon name? He named Warren Burger, Chief Justice, Harry Blackmun, Lewis Powell, and William Rehnquist. And as you think about Richard Nixon's appointments to the Supreme Court, it tells you something about the Supreme Court, but it tells you something even more important. And this is something that I think cannot be overemphasized. And that is the most important political development of our lifetime, which is the evolution of the Republican Party. The Republican Party of the 1970s is unrecognizably different from the Republican Party of today. It was basically a moderate party. It was not a religiously oriented party. It was not a socially conservative party. And when Nixon had all those appointments to the Supreme Court, people thought, oh, the court is going to move dramatically to the right, but it didn't. And the 70s at the Supreme Court were nearly as liberal as the 60s. Think about the big decisions of that period. You had the Nixon tapes case, where they essentially forced Nixon out of office. Pentagon Papers case, they approved school busing. In 1972, they ended the death penalty in the United States, though they let it back in 1976. And still, the most controversial decision of them all, 1973, Roe versus Wade, the case that said states could no longer ban abortion, was a 7-2 opinion. And the only two dissenters in Roe v. Wade were William Rehnquist and Byron White, who was appointed by President Kennedy. So 3 of the 4 Republican appointees to the court, Nixon appointees to the court, were in the majority in Roe v. Wade. Simply unthinkable in today's Republican Party. The big change, of course, began in 1980 with the election of Ronald Reagan, who brought with him to Washington someone who is, I think, a very underrated figure in recent American history, and that's Edwin Meese. Edwin Meese, he was an advisor to President Reagan, later the Attorney General, and he said, look, there has been a liberal agenda at the Supreme Court for a long time. We need a conservative agenda. And in appointing lower court judges, in enforcing the law, Edwin Meese really started to bring out this agenda. And so what was that agenda? Expand executive power, end racial preferences intended to assist African Americans, speed up executions, lower the barriers between church and state, and above all, overturn Roe v. Wade and allow states once again to ban abortion. Big part of the Reagan Revolution, as it sometimes calls, with the arrival in Washington of a group of aggressive young conservative lawyers, 2 of whom were John Roberts and Samuel Alito. And I think that is worth remembering about who they were and who they are. But the Republican Party of Ronald Reagan was certainly not the Republican Party of today either. And you saw that in Reagan's appointments to the Supreme Court. During the campaign of 1980, Reagan made a campaign promise that Jimmy Carter didn't even make. Reagan said, if I have the chance, I will appoint the first woman to the Supreme Court. 1981, Potter Stewart unexpectedly announced that he was leaving the court, so Reagan said to his people, look, I made a promise, keep it. Find me a qualified woman for the court. It was not, frankly, that easy in 1981. There were not as many women in prominent positions in the law, especially Republican women. So Reagan's people had to go all the way to the Intermediate Appeals Court in Arizona, not even the highest court in Arizona, to find the remarkable figure who was and is Sandra Day O'Connor. And at the time, it was clear that Justice O'Connor was not a social conservative, was not a hardcore conservative. She was a moderate, as she remained during her entire extremely consequential tenure on the court. And that was fine with Ronald Reagan. And that, again, tells you where the Republican Party was. 1986, Chief Justice Berger stepped down. Reagan elevated William Rehnquist from Associate Justice to Chief Justice. And Antonin Scalia was named to fill that seat. No question, conservative justice then, conservative justice now. Again, just a point that I think is especially relevant to the work that you do is that the conservative movement in the courts, by and large, is a more authoritarian conservative movement than a libertarian conservative movement. You know, that's a real split in the contemporary Republican Party between the sort of Rand Paul libertarians and the more traditional, pro-law enforcement wing of the Republican Party. Well, at least as far as the courts are concerned, it is very much the authoritarian wing of the party. So as you think about Republicans on the Supreme Court, they are largely a pro-government, suspicious of civil liberties kind of Republicans. That was certainly true of Reagan's appointments, and as you'll see, it's certainly true of George W. Bush's appointments as well. So 1986, Scalia goes on the court. 1987, a key moment in the history of the Supreme Court. Ever since the Warren Court, as I said, the court's been evenly divided, and there's been one swing justice, one justice in the middle who decides the outcome of a lot of cases. And in the 80s, it was Lewis Powell. So Powell left in 87, and that left a key vacancy on the court. And what did Ronald Reagan do? He nominated Robert Bork. And the country, really for the only time in our lifetime, had a national conversation about what the Constitution meant. Because Bork was brilliant, Bork was accomplished, he was prolific, he was an honorable man, but he was very, very conservative. And he had said things like the Civil Rights Act was a monstrous thing, and there was a no right to privacy in the Constitution. And that something important had happened between the confirmation of Scalia and the nomination of Bork the following year. In the midterm elections of 1986, the Democrats retook control of the United States Senate. And so the chairman of the Judiciary Committee in 1987 was no longer Strom Thurmond of South Carolina, but instead a young senator from Delaware named Joseph Biden. And Biden engineered hearings on Bork that really were a searching inquiry into Bork's views. And Bork's view, probably to his dismay, he answered all their questions. He didn't dodge them the way subsequent nominees have. And the Senate said too conservative. And he was voted down 58 to 42, and Ronald Reagan, facing political reality, nominated someone who was not as conservative, and that was Anthony Kennedy, who is no liberal, but is certainly not as conservative as Bork would be, and that really set the stage for the Rehnquist Court, which I wrote about in my book, The Nine. And, you know, when I started work on The Nine, I was inspired by a book that I'm sure is familiar to some of you, The Brethren by Bob Woodward, which was really the first behind-the-scenes book on the Supreme Court, which said that, you know, the court had all sorts of terrible internal rivalries. Everybody didn't like Warren Burger. If you know anything about the history of the Supreme Court, a lot of the justices have hated each other over the years. You know, William O. Douglas, the cantankerous liberal who served on the court, you know, longer than anyone in history. One summer he had a car accident, drove his car off a cliff in Washington State, and the first question everybody asked back at the Supreme Court was, where was Felix Frankfurter at the time? Because they hated each other so much. But Rehnquist was very popular among his colleagues. Why? Well, he engineered a tremendous reduction in the court's workload. In the 80s, the Supreme Court was deciding about 150 cases a year, and by the time Rehnquist died in 2005, they were deciding about 70 cases a year. Do the math. 70 cases divided by 9 justices, divided by 4 law clerks apiece. It's a cushy job being on the Supreme Court. No wonder they live so long, right? In the 80s, there was a proposal to add, there was so much work for the Supreme Court to add a sort of super appeals court underneath the Supreme Court, and it went to the White House for evaluation. And the White House counsel at the time assigned a young lawyer on his staff named John Roberts to write a memo about this proposal. And this is what young John Roberts wrote. While some of the tales of woe emanating from the court are enough to bring tears to the eyes, it is true that only Supreme Court justices and school children are expected to and do take the entire summer off. Now, the Chief Justice doesn't talk this way anymore. The summer off looks good from where he's sitting, and the court remains basically a congenial place. And while you are here in Washington, I urge you, if you can, go see a Supreme Court argument, because it's really the best free show in town, notwithstanding my remarks here today, although this is not free, as you know. And there is, of course, one very well-known fact about Supreme Court oral arguments. That is that there are 8 justices who are very engaged and very prepared and ask lots of hard questions, and Clarence Thomas never says anything. Now, February 22nd, which just passed, was the 8th anniversary, 8 years since Justice Thomas last asked a question at the Supreme Court. But it is true that he is a full participant in the court's deliberations, and he asks, and he writes as many opinions as anyone else, and the court remains, and he's a congenial member of the court. But in thinking about the Rehnquist Court, it is useful to think about the court in 2 parts. 1986 to 2000 and 2000 to 2005. And the dividing point in the history of the Supreme Court, and in many respects, to this day, a dividing point in the history of our country, is the court's decision in Bush v. Gore. Now, I admit I am somewhat obsessed, even today, with Bush v. Gore. You know, Justice Scalia does a lot of public speaking, and he often, you know, gets a kind of hostile question. He's like, oh yeah, what about Bush v. Gore? And he always says the same thing, oh, get over it. Well, I'm not over it. You know, when my last book before the 9 was a book called Too Close to Call. I wrote a whole book about the recount. For that book, I tried to interview Al Gore. I really wanted to interview Al Gore, talk about, you know, interview him for this. Obviously, you'd want to talk to him. Well, he wouldn't talk to me. He didn't want to relive the experience, so I wrote the book without him. Well, while I was working on the 9, I met Al Gore at a social occasion, and I said, you know, Mr. Vice President, you're not going to believe this. I'm writing another book where Bush v. Gore is at the center of it. I said, I think I must be the biggest Bush v. Gore junkie in the world. And he said to me, you may be second, which, you know, you got to give him a nod for that. Well, as I believe you know, Bush won that case and became president. And something important happened at the Supreme Court from 2000 to 2005. The court moved to the left. The court got more liberal. Think about the big decisions of that period. They ended the death penalty for the mentally retarded, ended the death penalty for juvenile offenders. They decided Lawrence v. Texas, the case that said gay people could no longer be thrown in prison for having consensual sex. And they rejected the Bush administration's position on Guantanamo Bay and the history of, and the treatment of the detainees in there. All of them liberal decisions. Why? Because Justice O'Connor, who was the swing vote of that period, became more and more alienated by the modern Republican Party. She didn't like John Ashcroft. She didn't like the war on terror. She didn't like the way the war in Iraq was being conducted. And above all, Justice O'Connor was alienated by an event that doesn't get talked about a lot now, but is, I think, a very important event in the history of the last decade, which is the Terry Schiavo case. A case about who should make decisions for critically ill family members, and it was at precisely that time that Justice O'Connor was dealing with the sad descent of her beloved husband, John, into Alzheimer's disease, so it was not just an academic issue to her. And eventually, in his second term, George W. Bush did have a chance to name 2 justices to the Supreme Court in very quick succession, and he named John Roberts and Samuel Alito. And finally, the modern Republican Party has its voice on the Supreme Court. And John Roberts is more conservative than the man he replaced, William Rehnquist, and Samuel Alito is a lot more conservative than Justice O'Connor, whom he replaced. And we see that in the history of the modern decisions at the court. We have, you know, so many decisions where, you know, law enforcement wins. The death penalty is expanded, except in certain circumstances. Certainly, the signal issue, the signal decision of the Roberts Court, I think, to this day, is the Citizens United case, which has greatly changed campaign finance laws, essentially begun, not ended, begun the deregulation of American political campaigns. You know, the crucial idea that the Supreme Court has accepted is that money is speech. You know, people talk a lot about the corporations are people. That's actually a fairly minor and even uncontroversial idea. I mean, I work for CNN, I work for the New Yorker. We are always waiving the First Amendment. We want access to proceedings. We say CNN has a First Amendment right. Well, we do. Corporations do have First Amendment rights. There is nothing controversial particularly about that. But what is controversial is the notion that money is speech. The idea of giving money to a campaign is like giving a political speech. That suggests, that metaphor means that you can't regulate it, just like you can't regulate speech. So the court is in the process of deregulating American politics. On racial issues, this is a court deeply hostile to affirmative action in any kind, and you saw that in an extremely important decision last year where the court struck down the critical part of the Voting Rights Act, perhaps the most important civil rights law of the past 50 years, which is in many respects now a non-entity, this law, because of what the Supreme Court did. There are exceptions. You know, people sometimes describe Justice Kennedy as a moderate. That's really a mistake. Justice Kennedy is not a moderate. He actually has very extreme views. He just has somewhat idiosyncratic passions. He is someone who does believe there should be limits on the death penalty, so he often sides with the four liberals, the four Democratic appointees on death penalty cases. And most importantly, Justice Kennedy is clearly a supporter of gay rights. And there have been only three decisions about gay rights in history issued by the Supreme Court. The Romer case in Colorado, Lawrence v. Texas, which I mentioned, and the Windsor case, striking down the Defense of Marriage Act last year. All three decisions were written by Justice Kennedy. But no one should think because of that Justice Kennedy is somehow a member of the liberal wing of the court. It's just simply not the case. And the most important thing any Supreme Court justice can do is vote with his or her feet. In other words, leave. Because justices know that their departure gives a president a chance to put his stamp on the Supreme Court for a very long time, for the decades-long tenure. And the most important thing you can know about Justice Souter and Justice Stevens, these two Republican appointees, they gave their precious seats on the court to a Democrat, Barack Obama, and he appointed Sonia Sotomayor and Elena Kagan. And it is worth pausing to remember, as I near my conclusion here, that the last three justices to leave the Supreme Court, three more different human beings you will never see. Sandra Day O'Connor, this tall, charismatic, outgoing former politician from Arizona. David Souter, the shy, reclusive bachelor from New Hampshire. John Paul Stevens, a wily antitrust lawyer from Chicago. Three different personalities, but they all had one important thing in common. They were three moderate Republicans who left the court completely alienated from the modern Republican Party. Souter and Stevens so alienated that they gave their seats to a Democratic president. The last thought I have for you is, what is the future of the Supreme Court? Well, in the best law school tradition, I will answer that question with a question. Who's going to be the next president? Because that's the only question that matters when you think about the history of the Supreme Court. You know, it is, we are going to have one kind of Supreme Court if Barack Obama is followed by Hillary Clinton, who was followed by Andrew Cuomo. We're going to have another kind of Supreme Court if Marco Rubio is president, followed by Ted Cruz. And I leave that thought with you and look forward to watching the future of it all unfold. Thanks very much for having me.
Toobin.